And
Yes.
sometimes when you're living in a case like that, you're living in a home and that's what you've known for years and years. You don't necessarily see how bad things have gotten. You don't necessarily see this the way that the rest of the world would. And this is truly the case in Southeast Ohio.
Welcome back to the channel. It has now been a little more than 3 weeks since the Sider family case in Ohio first made headlines. Since then, we've seen moments where the case appeared to be moving quickly, followed by long stretches where almost nothing seemed to happen. Even now, there still hasn't been an indictment. And if you're waiting for a grand jury to determine what charges will ultimately be filed, you may need to be patient because that process is likely going to take even longer. One major reason for the delay is that the second defendant in the case now has legal representation, and that attorney is asking the court for a competency evaluation. Before we get into exactly what was filed, it's important to explain what competency actually means in the context of a criminal case because it's often misunderstood and isn't quite what most people assume. Gary Sider Jr.'s attorney has asked the court for permission to file a motion requesting a competency evaluation under seal. If you remember, Gary Sider C's attorneys also requested a competency evaluation, but they filed their motion publicly while still avoiding the disclosure of most of the sensitive details. In Gary Sr.'s situation, there was already a medical issue that had resulted in a serious hospitalization. Because of that condition, he was eventually released on bond. Given those circumstances, many people weren't surprised when his legal team requested a competency hearing. There had already been concerns about diminished mental capacity, and his attorney had even raised the possibility of pursuing a defense based on not guilty by reason of insanity. That type of defense argues that the defendant was legally insane at the time of the alleged offenses and therefore unable to fully understand or appreciate their action. In cases where that defense is successful, the outcome may involve placement in a secure psychiatric facility rather than serving time in a traditional jail or prison. However, that's not what is happening here. This request isn't centered on whether Gary Jr. was legally insane when the alleged crimes occurred. Instead, it's focused on whether he is currently able to understand the legal proceedings and actively participate in his own defense. According to the filing, the defense states that questions have been raised regarding the defendant's competency to stand trial. The documents involved relate directly to his present mental condition and include a request for a psychiatric evaluation. The motion explains that these filings contain highly sensitive mental health information, including details that directly reflect his psychiatric condition. Because of that, the defense argues that making those records public would unnecessarily invade his privacy while also undermining the confidentiality that normally surrounds confidentiality proceedings. The attorney is asking for only a limited seal, not for the entire case to be hidden from public view. Instead, the request applies solely to the competency motion, the proposed court entry, and any documents specifically discussing Gary Jr.'s mental health or the requested psychiatric evaluation. The filing further argues that there is no less restrictive option available because the very substance of the documents revolves around his mental condition and the need for further evaluation. For that reason, the defense believes there is good cause to allow these specific records to remain under seal. Essentially, the request is aimed at preventing the public from accessing information related to concerns about his mental health. Those concerns could come from several different sources. They may arise from the attorney's own interactions with Gary Jr. They could also come from correctional officers or medical staff at the jail if they've observed unusual, disruptive, or erratic behavior that raises questions about his ability to function. Likewise, if his attorney finds that he cannot effectively communicate, understand what's happening, or assist with preparing his defense, the attorney has the authority to raise the competency issue with the court. The Ohio Supreme Court provides guidance on how competency is evaluated, and the Ohio Criminal Sentencing Commission explains that competency to stand trial depends on whether the defendant can understand the nature and purpose of Under Ohio law, a defendant is considered incompetent if either or both of two conditions exist. First, if the defendant cannot understand the nature and objectives of the proceedings against them. Second, if the defendant is unable to assist in preparing or participating in their own defense. If someone is found incompetent, they cannot legally be tried or convicted unless and until competency has been restored. A defendant also must be competent before waiving the right to an attorney or entering a guilty or no contest plea. That's an important distinction because this evaluation has nothing to do with Gary Jr.'s mental state when the alleged crimes were committed. Instead, it looks only at his current condition and whether he is capable of participating in the legal process today. Competency isn't necessarily permanent. It can change over time, and the stress of incarceration alone can sometimes affect a person's mental condition. We've seen similar situations in other high-profile criminal cases. Lori Vallow, for example, was previously found incompetent to stand trial. She was transferred to a mental health facility where doctors worked to restore her competency. Once professionals determined that she had regained the ability to understand the proceedings and assist in her own defense, the criminal case moved forward and she ultimately stood trial. If Gary Jr. is found incompetent, the restoration process could take a significant amount of time as well. The Ohio Criminal Sentencing Commission further explains that competency to stand trial is a legal determination made by the judge and a defendant A plea of not guilty by reason of insanity, on the other hand, addresses something entirely different. That defense focuses on the defendant's mental condition at the time the alleged offense occurred and whether the individual was capable of understanding that their actions were wrong, Competency to stand trial and a plea of not guilty by reason of insanity are two completely separate legal issues. Although both can be raised in the same criminal case, they serve different purposes. If attorneys choose to pursue both, the court may even order evaluations that address each issue at the same time. Even so, judges generally resolve competency first before turning their attention to an insanity defense. So, how does the competency process actually work? Under the law, every defendant is presumed to be competent unless there is a legitimate reason to question that assumption. In other words, competency doesn't automatically become an issue. It has to be formally raised. Who has the authority to do that? The defense can raise it. The prosecution can raise it. And the judge can also raise the issue independently if circumstances warrant it. As for timing, a competency question can come up either before a trial begins or after proceedings are already underway. If it's raised before trial, the court is required to hold a competency hearing. Or if the issue surfaces after the trial has started, the judge has discretion to decide whether a hearing is necessary, although one generally should be held when there is good cause. Several factors can support a finding of good cause. Those include medical reports discussing the defendant's mental condition, evidence of irrational or unusual behavior, the defendant's conduct during court proceedings, concerns expressed by defense counsel regarding the defendant's ability to participate in the case. Whenever competency is being considered, the defendant must be represented by legal counsel throughout the process. The hearing itself generally has to take place within 30 days after the competency issue is raised. If the court orders a mental health evaluation beforehand, That evaluation must usually be completed within 10 days of the filing. If the initial evaluator recommends additional testing for intellectual disabilities, another report is prepared within the required time frame before the court continues the process. The court cannot simply declare someone incompetent because they have previously received treatment for mental illness, have been diagnosed with an intellectual disability, or currently take psychiatric medication. Even if stopping medication could affect their mental state, those facts alone are not enough. Required evaluations and legal procedures still have to be completed before the court can reach a decision. Ultimately, any finding of incompetency must be supported by evidence presented through the evaluation process and accepted by the court. Once those evaluations are finished, several different outcomes are possible. The first possibility is that the court determines the defendant is competent to stand trial. If that happens, the criminal case simply moves forward through the normal legal process. Another possibility is that the defendant is found incompetent but restorable. That means the court concludes the defendant is currently unable to proceed, but there is a substantial likelihood that competency can be restored within the legal time limits if appropriate treatment is provided. That treatment can involve placement in a specialized treatment facility, therapy, psychiatric care, or medications designed to stabilize the person's mental condition. Lori Vallow's case is one example that comes to mind. If I remember correctly, she was diagnosed with a psychiatric disorder, and medical professionals worked to stabilize her through a combination of medications before she was eventually found competent to stand trial. That restoration process took time before her criminal proceedings could continue. The court is also expected to choose the least restrictive treatment option that still meets the defendant's needs. There are situations where the court determines that additional time is needed before deciding whether competency can realistically be restored. In those cases, the defendant is considered presently incompetent, but the court cannot yet determine whether treatment will successfully restore competency within the 1-year period allowed for felony cases. Different statutory timelines apply in misdemeanor cases. Then there is the final category: incompetent and unrestorable. For felony cases, that finding means the court concludes the defendant is incompetent and that there is no substantial probability competency can be restored within the period established. When that happens, the court or the prosecution may file an affidavit in probate court seeking civil commitment, and the court may also retain jurisdiction over the defendant either on its own initiative or at the prosecutor's request. Looking specifically at this case, it's understandable why defense attorneys would want to carefully examine the defendant's mental health and competency. The parents were reportedly living in the same extreme conditions as the children. In circumstances like that, most defense lawyers would naturally explore whether there were underlying mental health concerns, intellectual disabilities, or other issues affecting their clients because, generally speaking, mentally healthy individuals do not choose to live under those kinds of conditions. Of course, there are several possible explanations. Substance abuse is one possibility. That region has struggled with significant drug problems, so addiction could certainly contribute. Mental illness is another possibility. An intellectual disability could also be involved. If I'm remembering correctly, there was speculation from some family members, although it was never confirmed, that Gary Jr. was not particularly intellectually capable. Some even suggested he might have developmental or intellectual limitations. Again, those were simply claims made by relatives and not established facts. At the same time, there's another important point to consider. Based on what's been reported during the period surrounding the alleged crimes, the group appeared to understand that law enforcement was looking for them. They reportedly moved from place to place, avoided being located, and changed locations repeatedly. Those actions suggest that someone involved understood they needed to conceal what was happening and avoid being caught. But that's still separate from the legal question the court is considering today. The issue isn't whether Gary Jr. was competent while the alleged crimes were taking place inside the home. The question is whether he is competent right now to understand the legal proceedings and assist his attorneys in preparing his defense. Another interesting detail is that his attorney is only now asking for a competency evaluation. That could indicate this concern developed recently. It's entirely possible he was capable of participating in his defense until this past week, and then something changed that prompted counsel to bring the issue before the counsel to bring the issue. At this point, we simply don't know what prompted the request. And if the motion is ultimately allowed to remain under seal, there's a good chance we may never know the specific details. I understand why that's frustrating for people who are looking for answers and hoping to see justice move forward as quickly as possible. But the legal system is designed to make sure every required step is followed. As difficult as delays can be, it's essential that every procedural safeguard is respected. One of those safeguards is ensuring that no one is put on trial unless they are legally competent to participate. For those seeking justice for the children, that should matter too. You want every defendant to fully understand the proceedings, be able to work with their attorney, and meaningfully participate in their defense. Convicting someone who cannot even comprehend what's happening would undermine the integrity of the justice process. It's also important to remember that being declared incompetent does not mean a defendant is simply released. If someone is found incompetent and is believed to have committed these crimes, the state can still maintain custody through other legal avenues. That person may be committed to a secure mental health institution and remain under state supervision rather than being set free. There's another distinction that's worth emphasizing because it's often misunderstood. Competency is not the same thing as ignorance. Being uneducated, uninformed, or unfamiliar with the legal system does not make someone legally incompetent. Competency is about whether a person can think rationally, understand the proceedings taking place, and actively participate in their own defense. Someone who has never been involved in the criminal justice system can still be fully competent. Their attorney can explain the process, answer questions, and help them understand each stage of the case. The concern only arises when a defendant cannot communicate rationally, cannot understand what's happening despite those explanations, or cannot meaningfully assist counsel in preparing a defense. That's where competency becomes a legal issue. Looking ahead, I believe mental health is likely to play a significant role in this case. At the same time, I also think it's entirely possible that some members of this family will ultimately be found fully competent. Take Christina or Lynn, the grandmother, as an example. People who have spoken about her have consistently described someone who appeared capable and engaged in everyday life. According to those accounts, she regularly visited the local food bank, proudly cared for the children, and interacted normally with people in the community. Based on those descriptions, she seemed to understand what she was doing and functioned independently. Likewise, Elizabeth's attorney has never suggested that she lacks the ability to understand the proceedings, at least based on what's been presented publicly. There has been no indication that competency is an issue for her, so it's entirely possible she will be found competent to stand trial. One detail I'm still curious about involves Gary Jr.'s intake at the jail. Reports indicate that he was intoxicated when he was booked, and that naturally raises questions about what substance may have been involved. Was it alcohol? Was it alcohol? Was it alcohol? The area where this case took place has long struggled with illegal drug activity. There are reports of injectable narcotics as well as widespread use of methamphetamine, what many people used to call crank. Because of that, it's reasonable to wonder whether substance use played any role here. What's interesting, though, is that the arrest reports themselves don't mention officers discovering drugs or recovering illegal substances during the arrest. The only information that's been reported is that he appeared intoxicated upon arriving at the jail. So at this point, we simply don't know. On the other hand, if he's intentionally pretending to be incompetent, that's exactly the kind of issue a professional competency evaluation is designed to uncover. Not everyone who undergoes a competency evaluation is ultimately found incompetent. Likewise, having a mental illness by itself does not automatically make someone legally incompetent. For example, if a person is experiencing severe psychosis, schizophrenia, bipolar disorder, or another psychiatric condition, treatment and medication may stabilize those symptoms enough for them to regain the ability to think clearly, understand the legal process, and assist in their defense. That's the goal of competency restoration. As discussed earlier, something similar occurred in Lori Vallow's case. If I remember correctly, she was dealing with significant psychiatric issues, and treatment, including medication, was necessary to stabilize both her thinking and her mood before she was eventually declared competent to proceed. If Gary Ginger is struggling with untreated mental illness, experiencing the effects of substance withdrawal, or dealing with another condition that's preventing him from thinking rationally, the evaluation process should help determine what's actually going on. Whatever the explanation may be, the legal process pauses until that question is answered. The same is true for Gary C. Based on everything we've seen so far, this already appears to be a case that will take a considerable amount of time before reaching trial. Regardless of how the criminal proceedings ultimately unfold, however, one issue appears much more settled. The state is pursuing permanent, full custody of the children, and based on everything that's been reported so far, there doesn't appear to be any expectation that they will be returned to their parents, regardless of the eventual outcome of the criminal case. I'd love to hear your thoughts on all of this, so let me know what you think in the comments below. If you found this update helpful, don't forget to give the video a thumbs up, subscribe to the channel if you haven't already, and turn on notifications by clicking the bell so you never miss another update. Thanks so much for watching, and I'll see you in the next one.